Atiku begs Supreme Court on fresh evidence against Tinubu alleges forgery. I know this is coming at the heels of this period where Supreme Court or some people are alleging that Supreme Court will not accept any fresh evidence. But again, it is obvious that the Supreme Court will give opportunity for fresh evidence, and in line with that, Atiku had brought a lot of evidences from the USA, Chicago State University, carrying Tinubu's record as fresh evidence to prove that Tinubu actually forged the certificate that he submitted to INEC. So in the midst of all of that, Atiku is now speaking to the Supreme Court justices to allow him or to admit his fresh evidences against Tinubu. Wow. The presidential candidate of the People Democratic Party in the February 25 election, Atiku Abubakar, has urged the Supreme Court to allow him to present fresh evidence to back his claim that President Bola Tinubu forged the document he submitted to the Independent National Electoral Commission. He said presenting forged documents by any candidate is a grave constitutional issue that must be discouraged. This was contained in Atiku's reply on the point of law to Tinubu's objection to the leave. He sought to present fresh evidence before the Apex Court. Presenting forged documents by any candidate, especially by a candidate for the highest office in the land, is very grave constitutional issue that must be discouraged, that must not be encouraged, he said. Tinubu has urged the Supreme Court to dismiss the application, describing it as a crass abuse of court processes. But in his response on the point of law, Atiku urged the court to jettison technicality and grant his application. He argued that the issue of merit ought not to be determined or pronounced upon at the interlocutory stage. Now, to refuse to grant the leave, as the respondent has argued, will amount to undue technicality. The Supreme Court, as the Apex Court and indeed the Policy Court, has intervened time and again to do substantial justice in such matters of great constitutional importance, as it did in the case of Amechi versus INEC 2008, 5 NWLR Part 1080, 227, and Obi versus INEC 2007, 11 NWLR Part. This is now the serial numbers and reference numbers of those cases. The Supreme Court applied the principle of ubi jus ibi remedium to ensure substantial justice is done in such move scenarios. The need to rebuff, eschew, and reject technicality and the duty of court, to ensure substantial justice is very germane in this matter, given the gravity of the constitutional issue involved in deciding whether a candidate for the highest office in the land, the office of the president of the country, presented the forged certificate or not. In urging the Honorable Court to overrule the objections of the respondent, we can do no better than to commend to your noble lordship and insightful words of the Supreme Court in ASA and ORS v. Kara and ORS 2014. All these are cases that are trying to bring to us. Law is blind, it has no eyes, it cannot see. That explains why a statue of a woman with her eyes covered can be found in front of some high court. On the contrary, justice is blind, it has many eyes. Justice is not blind, it has many eyes, it sees and sees very well. The aim of court is to do substantial justice between the parties, and any technicality that rears its ugly head to defeat the cause of justice will be rebuffed by the court, he said. Atiku stated that his stance was not if Tinubu attended Chicago State University or not, adding that Tinubu presented a forged certificate to INEC. Bam. Okay, that the case is not whether the second respondent attended Chicago State University, but whether he presented the full certificate to the Independent National Electoral Commission. That at the trial, a National Youth Service Corps certificate with serial number 173807 presented by the second respondent to the first respondent, was equally tendered by the applicant, at the trial as Exhibit PBD1A with the name Tinubu Bola Adekunle, which is annexed herewith as Exhibit J. Oh boy. Also, Atiku described Tinubu's allegation that he was not consistent with his name as immaterial and pedestrian. This one, wow. So with all of this now, the case Atiku is pursuing is not whether Tinubu attended Chicago State University or not, but the credibility and the originality of the certificate that he submitted to INEC when they were filling out the INEC form for the 2023 election. That is the issue. And that is where the controversy is, because up till now, there are still, the records are still not consistent. The records are still not consistent. Okay? The records are still not consistent. So it means what this guy is asking Supreme Court to do is to ensure that they accept the document that he has brought from the Chicago State University as exhibit. He argued that the president made a move to block the release of credentials while he had equally applied through his lawyers for the release of the document. That the second respondent had been in primary possession of all the facts sought in the discovery, but took every step to block their release, notwithstanding that the second respondent had equally applied through his attorney in the United States, Mr. Wole Afolabi, for the release of the said document, which were released to him as shown in Exhibit P, presented in the course of the discovery and the position process, he said. So the thing here is that Tinubu made every step through his lawyers to block CSU and U.S. court from releasing those documents to Atiku. Meanwhile, they on their own part, they have all those documents already. So by the end of the day, that did not work. The Judge Nancy Maldonado, at the end of the day, had to order the stay, order the upholding of the lower court judgment, instructing CSU to release the Tinubu's document, which eventually they released that document. Okay, so these are documents that Atiku is seeking to tender. My fear is it not late? Because it looks like all of this is late, but he knows his way and is working to ensure that they admit those new and fresh exhibits, as they will have a way of buttressing and further explaining his claims during the court proceedings. So thank you for listening, and let's have your comments.